everyone. We are working on going live here, giving it just a minute to let Instagram connect. Here we go. Now we're going to get here on TikTok. I have to change that title on TikTok. All right. Hello, everyone, and welcome to this week's live. Sorry, my printer behind me has just decided to go a little nuts. Hopefully it's going to stop in any second now. Okay. So today we are here today to talk about child custody basics in Texas, that being conservatorship and possession and access. Custody is not a word that you are going to see in any Texas child custody order. There are two categories that kind of fit into that custody category. The first one would be conservatorship. This relates to rights. When we hear people use the term joint custody, usually they're talking about conservatorship, but they may be talking about possession and access, which is the schedule. So first, let's go ahead and talk about conservatorship. We have two different options for conservatorship. We have joint managing conservatorship, which is what most parents are. Vast majority of parents are joint managing conservators with basically equal rights, but they can be tweaked in a variety of ways that we'll talk about in just a minute. The other option would be sole managing conservatorship. This is where, one parent is the sole managing conservator. If there is another parent, that parent is a possessory conservator. The sole managing conservator has all the big rights exclusive, and the possessory conservator has much lesser rights. We have a lot of people come in who want sole managing conservatorship, and it is not realistic for most people unless you have a protective order, you have a history of serious domestic violence or child abuse issues, you have someone who has been completely MIA and they're not around. In those types of situations, you can get sole managing conservatorship sometimes, but not always. Most people are looking at joint managing conservatorship. Usually, but not always, one parent has the exclusive right to designate the primary residence within a certain geographic restriction or certain geographic area. So having the right to designate the primary residence is a very important right. Not only does that involve, usually the child's going to go to school based on your house, but it can come with a lot of other legal significance, some of which might not be apparent at the time of this order. If we're looking at a future modification, there are a lot stricter requirements to change certain things. If we are trying to change the primary residence, if we have a non-parent involved in a subsequent modification, having that primary designation might matter. So it's something that generally most parents are going to want to have. We can't give it to both. So, you're certainly going to want to see what is appropriate in your situation. I mentioned the geographic restriction. In Texas, it is the public policy of the state of Texas that kids should be able to see both of their parents on a regular basis. And to do that, we restrict where the child's primary residence can be. If we have a parent designating the primary residence, then really it's going to be restricting that parent. If we have a 50-50 schedule and no primary, then it's going to be restricting both parents to living within that zone. We've seen geo restrictions of all kinds. If you go to court and a judge does it, it's usually going to be either the county where you currently live or the county and contiguous counties. I personally think county and contiguous counties, which is every county touching that county, is overly broad and way too far, and means that everyone's going to be spending a ton of time driving. If we're looking at, for example, Dallas and contiguous counties, you could have someone that is living in the northeast corner of Collin County and then someone else who is living in the southwest corner of Tarrant County. And that's really far away and can become a really big burden on your children. Oftentimes we will come up with other geographic restrictions by agreement that make sense. we'll do a radius around a certain point. I've seen things like between the George Bush and 380 and between the Tollway and 75. It can be anything. It could be a certain school district. I always recommend, you want to make sure that everyone is going to be able to find a place within that zone, and everyone is going to be able to afford to live within that zone. So you don't want it to be too tight if either of those things are a concern. But in general, in my experience, the closer people live together, the better it is. There are other rights in talking about conservatorship, other rights that can be allocated a variety of different ways. These are things like the right to make educational decisions, the right to enroll the child in school, the right to make invasive medical decisions, the right to make psychiatric and psychological decisions. There are different ways each one of those can be allocated. They could be exclusively given to one parent. Even if we have joint managing conservators, we may have a situation that warrants one parent having exclusive rights for medical or exclusive rights for educational. We can require joint agreement. This is great if we have people who are good co-parents. If we have, for example, for medical decisions, if we have a parent that is team science and a parent that is anti-vax, it is going to be very hard for those parents to agree on medical decisions. So somebody's going to need to have the exclusive right. We can have independent rights where each parent has the right individually. We do see this a lot. I normally recommend it in situations where, let's say our client is going to be the primary parent and they've always been the primary parent. They've been the one who takes the child to the doctor, goes to the parent-teacher conferences, all the things. And the other parent wants to be joint managing conservator, but is very unlikely to take action. In that scenario, let them have the independent rights, and our client can kind of do whatever they want without the other one be involved or meddling or having to agree. Oftentimes we'll have independent rights after prior consultation or after prior notice. That way, if there is going to be any sort of dispute between the parties, there is an opportunity for someone to seek court intervention to get help. If parent A says, I'm going to have this invasive surgery done to our child in 48 hours, parent B, who might not think it's a good idea or might want a second opinion, will have an opportunity to ask the court for a temporary restraining order and ask the court for guidance on making that decision. The next category we have when we're talking about child custody would be possession and access. And this relates to the schedule. When is the child going to be with mom? When is the child going to be with dad? In the Texas Family Code, we have only one schedule with a few different variations. We call it the standard possession order. And it includes schedules for less than 50 miles, 5,200 miles, or over 100 miles. Standard possession order is the minimum presumed amount of time that a parent should have with their child if that child is at least 3 and up. And it's about a 60-40 split. It can vary a little bit based on, 50 miles or less is more time than 100 miles or more for the non-primary parent. And it can also vary a little bit based on the particular school holidays in any given year, but roughly 60-40. We have a lot of people ask about 50-50 schedules. There is nothing in the family code that talks about 50-50 schedules. It doesn't talk about schedules, doesn't talk about child support for 50-50. Absolutely no guidance there. In practice, usually we see 50-50 schedules happening by agreement. But if you're going to court, this is a very judge-specific thing. This is why it is important that the firm that you hire practices regularly in your county, is familiar with your particular judge, and knows, is your judge a 50-50 judge or is your judge a standard possession judge? Because if your judge is a standard possession judge, for example, I have had judges tell me, you can tell your clients, I will never, ever order a 50-50 schedule. And when you have a judge like that, that is not a hill that you die on in court. You want to try and reach agreements one way or another to see if you can get to 50-50 or something close to it. But you know that if you go in court and ask for 50-50, your odds are slim to none in those courts. There are other judges who really like 50-50 schedules and think they work great. I have seen judges order 50-50 schedules when neither parent asked for it, when both parents were asking for primary. So you also want to know if you have a judge that is likely to do that, because it can really impact your settlement discussions and help you decide whether or not something is worth fighting for in court. There are others, keeping on the 50-50 schedule track, I would say we have two common 50-50 schedules that we see. One being week on, week off, Friday to Friday, Saturday, Sunday to Sunday, something like that. I usually see these being common and well liked by people with older children. The other common schedule that we use, we would call a 2-2-5-5, which is one parent has every Monday, Tuesday, one parent has every Wednesday, Thursday, and you alternate the weekends. I think people tend to like this with younger kids where, a week is a really long time for a child not to see one of their parents. Elementary schools often will have their homework given on a Monday and it's due on Friday. And with a 2-2-5-5, every parent can touch that during the week. If dad wants Johnny to take hitting lessons, he can put that on Monday or Tuesday. If those are his days. If dad wants Johnny to be on the baseball team, then he's going to have to get mom to agree, because that's going to cover both sides' schedules. Mom wants Johnny to take piano lessons, and she could put that Wednesday or Thursday if those are her days, and she's going to have it every week. There's also a schedule that you might hear about called a 2-2-3, which is where instead of one parent having every Monday, Tuesday, it's just strictly one parent has the first 2 days, other parent has the second 2 days, first parent gets that weekend, and then it flips. I think a 2-2-3 schedule is absolutely ridiculous. I advise everyone against it. It's so confusing. With a 2-2-5-5, you can look at any week of any year and you can know exactly when you have the child and when you do not. With a 2-2-3, you got to be, looking at that flip-flopping schedule and really making sure everybody's on the same page about who has what when. So there are other unique schedules that sometimes we have to use based on the unique circumstances of clients. Firefighters, for example, will have schedules that account for if you're on A shift, it's this. If you're on B shift, it's that. C shift, it's that. Pilots, we've seen where schedules aren't available until a certain time, and they're very different. And we'll have certain notice requirements and how we're going to handle that. So that pretty much covers the basics of conservatorship, possession, and access in Texas. Join us next Wednesday. We're going to hop on every Wednesday that we aren't gone on vacation to bring you all the latest updates and information about Texas family law. If you have specific issues you would like for us to address, feel free to shoot us a DM or drop a comment. We'll try and address that in a future episode. Thanks for joining us.